When a trial concludes, we say that the case is now in the jury's hands. And when a person gets married, a ring gets placed on their hands, and it's worn as long as both shall live. And when a son is born, a family first looks at the hands, and the family members say, what? It's okay. He's got 10 fingers, he's got 10 toes. Well, last Tuesday we told you that Luis Garcia was killed by the defendant, Brandon Castiglione. And if this trial now concludes, the case will be in your hands. And 4 days before her wedding anniversary, Patricia Garcia found out that her husband was not okay. And now that ring on her hand was from a man who was never going to pick up that phone again. And a family, a sister, a grandmother, Danielle Padovano and Francis Pastana, they saw what their brother and grandson had done with his hands. And it was not a dream. It was a nightmare. Simply put, there is no mystery who the murderer is in this case. It's the defendant. The same man locked inside his house with Luis and no one else there but the two of them. His pistol locked inside his cabinet. This gun that was used to kill Luis Garcia by shooting him in the back of the head. And in the process, left fingerprints on it. His spent bullet casing on the floor, the one that came from his gun. Loaded from his ammunition from the top drawer of his bedside cabinet. The same as the only bullet casing in the room where Luis was shot and killed. And from this casing, his bullet on the floor. The one missing 2 pieces that was still in the back of Luis's neck. The bullet fired from that gun. And the only bullet in the room. It wasn't self-defense. It wasn't an accident. This was not a botched investigation. And it wasn't some mystery man like the defense wants you to speculate about. What you just heard from the defendant in openings just now was speculation. And speculation is not evidence. Evidence doesn't come from this podium. Evidence comes from that witness stand. Evidence comes from the exhibits, the stipulation, and what you saw in this courtroom. They want you to ignore the evidence and look anywhere else but where all of the evidence points to. The man who shot Luis Garcia with his Glock 9mm pistol, serial number TSA-446, that was loaded with Fiat all-copper 92-grain ammunition. The man sitting right there, Brandon Castiglione. Luis. He was a father, he was a husband, a friend, a counselor, and a minister. And his hands were at work constantly. And you remember hearing that when his asthma didn't let him go in and out of those refrigerated meat packaging and seafood packaging plants anymore, he had to switch over to painting. He started doing finish painting. And Luis was also a minister at New England Pentecostal. Not an ordinary minister. He built with his hands. He built a sign for the church. He cooked. He did security for the church. You heard how he sat and spoke with others, counseled them through the best and the worst moments of their lives. He attended services on Sunday, Bible studies during the week, Monday prayer sessions, some of which were led by Minister Eddie. And in addition to all that, we heard how Luis took the time to try and counsel the defendant. The defendant's behavior leading up until the point of the murder, you heard, have become and had caused a concern in the church. This caused Luis to have an interest with this defendant that was beyond just being friends with each other. But as someone in charge of church security, he now had to have the security of others in mind. Luis began doing work at where the defendant lived, doing things like stripping wallpaper and painting for Mark Castiglione, the defendant's father. He had been doing it for more than a week before the defendant shot him. So Brandon knew that Luis was going to be coming over that day. Luis got into the house that day the same way he usually did, by using the key that was left for him under the mat on the mornings that Luis would come to work. A key that otherwise wasn't there. It was just for Luis on the days he was coming. You heard that from Mark Castiglione. No one else knew it was there. Even Mark's daughter, Danielle Padalano, and his former in-laws, Fran and Jeff Pestana, didn't know that it was there when they came over later that day and tried to get a hold of anybody in that house, desperately trying to reach somebody inside. On October 1st, 2019, Luis started his day at home. We know from Mrs. Garcia he left the house around 8 o'clock in the morning, alone. We know his phone logged the last call that he ever had was somewhere between 7:45, the call being made at 7:45 in the morning, to Minister Eddie. With his drive from Manchester to 15 Richmond Drive in Londonderry, common sense is going to tell us that can't be more than 20, 30 minutes tops. So on this Tuesday morning, Luis has hung up with Minister Eddie, arrived at the house, parked his Subaru in the driveway, the only car that Frances Pestana ever sees there, when she arrived later and went inside. Car in the home that has no garage, as you remember from reviewing through the photos of the different windows and entrance and exits. Has no garage. No other car seen there. Luis gets there, parks, and goes inside. A little over an hour later, maybe even less, this defendant had shot and killed Luis. We know that from Luis's phone. We don't know what caused it to happen in that hour, but we know something was different. We know something was wrong. You've heard testimony from multiple witnesses that Luis regularly picked up his phone when people called. Mark called him on that morning, on his morning break, just like he ordinarily would. 9:31 a.m. Call went through. Brother Mark tried to call, missed call, about 9:30 a.m. This was what Mark usually did when Luis was going to be there. Brother Mark called, but very unusually, Luis did not pick up, because Luis was likely already dead. Mark didn't know that. Maybe Luis was busy working or turned his ringer off. Mark did what? Tried the defendant. Very next call, very next minute. The defendant did not pick up his phone either. Not all the rest of that day. The phone records proved that Luis was dead a little over an hour after getting to 15 Ridgemont Drive, because otherwise Luis, as he ordinarily did, would have picked up his phone. And the defendant didn't pick up his phone either during that same time period on forward, because whatever motivated the defendant to go through the process of getting his Glock from the locked cabinet, walking up behind Luis, raising his arms, pointing the Glock at the back of Luis's head, and pulling the trigger, knowing that Luis would die, when he shot Luis from behind, That must have taken place within that hour too. Big question. The only real mystery in this case is, why did the defendant do this? That's the mystery. And one tragic truth that every single one of us realizes, whether we've said it out loud to ourselves or not, whether it's in our own lives, our friends' lives, our families' lives, what we see on the news, one tragic truth is that every single day, people who love each other hurt the people that they love, or the ones who are trying to love them. And sometimes they even kill them. Sometimes there's no reason. And sometimes there's no good reason. Sometimes there's no reason at all. Human beings, we're not machines. Human beings don't do exactly what we expect them to do. The defendant certainly didn't think that Luis would see him coming. That's why he shot him in the back of the head. We'll never know why the defendant murdered Luis. We only know that he did. We only know that he shot him, and he knew it would kill him. And the charges in this case don't require the state to prove motive of why he killed Luis. That's important. That's worth repeating. Motive is not an element of the crime of murder. It's impossible to read a person's minds. We can speculate why he did it, though, can't we? Was it an argument over religion? Over Luis's role of the church, overseeing security, stopping the defendant's behavior there? Something from the midnight prayer session the night before, maybe. Why he called Minister Eddie? Was it resentment of the counseling that Luis was giving him and trying to tell him what was and what was not? A disagreement over what the word was? Was the defendant contrasting his own situation and coveting Luis's stable life and faith? We don't know. And we never will. And as much as we want the why, and why do we want the why? We want the why because it makes sense of the senseless, right? The why isn't something that the state has to prove. Just the who. Who killed Luis? And he's sitting right behind me right now. The same person whose behavior and demeanor had changed in the weeks leading up to the murder. And the testimony that we shows he was thinking about Luis. So if murder did have to be shown, then that would be an indication that something had shifted, possibly toward. Were the two men friendly? That's what we heard. Was there tension? Was there disagreement? Was there conflict between the two men? We definitely heard that too. Again, even though motive is not something we have to prove, you can and should consider that it was the defendant who is the only one that you have heard has any motive to kill Luis. And again, it's an ugly truth, but we know it's a truth. People do terrible things sometimes for no good reason. No reason at all. During the argument that you heard just a few minutes ago, Attorney Harwood presented a theory, great theory, but it was without evidence. Pure speculation. Appointments, except when his grandparents would pick him up to do service in the nursing home on Mondays, or they would drive at nighttime to prayer or Bible studies. That's what we heard. He was in the house with Luis on October 1st, 2019, with nowhere else that he was supposed to be. That is evidence. Just like it's evidence that the house was secure and there was no sign of forced entry. We looked at every single one of those windows, every single one of those doors. And the killer didn't have to break in to kill his victim because they were both already there. The killer was already there, and so was the weapon that the killer used. And you heard that that gun was the gun to kill Luis. A gun that belonged to the defendant. This weapon was his gun. Nobody else. Certainly not the mystery man that they want you to believe in. Who would what? Break into a home, use a gun to shoot a person painting, than leave the gun and walk away? You heard the evidence and you saw the photos. Nobody broke into the defendant's house, let alone broke into the defendant's locked cabinet and used his gun to kill the victim. The key we looked at a minute ago, we've never heard any testimony from any witness that that was the key that opened up that particular cabinet. That's because the killer used his key to open that cabinet next to his pillow and get his gun, and in the process left his fingerprints on that gun. Then walked right around the corner into Danielle's old bedroom, now Mark's office space, and aimed the end of that barrel that we know is a couple of inches to no more than 12. From Dr. Duval, we know that's the distance between the end of that barrel and the back of Luis's neck. And the gunshot fired straight across his body, his spinal cord, right dead in the middle of the center of his body. It wasn't some mystery person that did this and left no trace. What? Obtaining the gun from the locked cabinet that he doesn't know where the key is, shooting Luis, then leaving the gun, then leaving the house locked, sneaking out without locking down anything. Shelves, post-it board, box. If you look, basket, perched off center at the top. Shot Luis, didn't disturb anything, didn't leave anything, and then disappeared without a trace. It was the defendant who got his gun and loaded it and made it ready and had plenty of time to do it that day because his victim was coming to him. The defense wants you to speculate on when this happened, saying somebody could have come by between Luis getting there and Danielle and Fran being told about the key so that they could finally get inside. But we know from his phone that Luis was on the phone with Minister Eddie from the church starting at 7:45. Remember, it goes for 28 minutes and a few seconds. Hung up his phone at 8:14 a.m. When Mark tries to call him, Luis doesn't pick up. When the defendant doesn't pick up, Luis continues to never pick up. That's at 9:30. That's 76 minutes. Within 76 minutes of his arrival, Luis is not picking up the phone like he usually does. That's not speculation, that's evidence. And Mark told us how he knew Luis was coming over that day. That's why he put the key under the mat. He did it just for Luis. There's no evidence that somebody else in 76 minutes that morning came over, found this key, went inside and did this. Something is wrong in that time period. You know that from more than just the jail calls, too. Exhibit 7. We can see from the photo that the sanding block's fallen there at his feet. The wall's being prepared, right? The room is ready to paint, drop cloths are out, but he hasn't started painting the walls yet. You know he's dead because his hands are as clean as a whistle. Anybody who's ever picked up a roller or a brush knows there are no flecks of paint on Luis's hands. His workday had just barely begun when he was killed. That's not speculation. That's evidence of when this happened. Defense wants you to speculate that the defendant's failure to answer his own phone when called wasn't because he was avoiding discovery of his crime, but because he was praying so intensely and he just shut out the world for hours. But what's the evidence? We know what's wrong at 9:30. So 9:30, 10:30, 11:30, 12:30, 1:30, almost 2:30. Remember, Officer Phillips testified that he received that initial dispatch to get there around 2:28 in the afternoon. So we can call that about 2:30. So for 5 hours. Prayer so devout that he didn't respond to any external stimuli for 5 hours. What was he praying for? Help, one would think. But he didn't call 911. He didn't do anything for 5+ hours. The physical evidence shows that he didn't do anything to help Luis at all. Look at the photos of the crime scene when you're deliberating. None of that blood was stepped in or moved or splashed before the police got there and got around the defendant to Luis. No one got Luis's blood all over them, the mystery man. The defendant didn't go anywhere for help. Mark testified that he believed, well, the second car was leased at one point, but then maybe not. Police didn't see any second car there. Fran told you she was there.
Objection, facts not in evidence.
The jury will use its own recollection of what the facts were.
Thank you, Your
As
Honor.
I've already instructed the jury.
The police didn't see any second car there, and no car was reported missing, stolen. So he didn't leave in a car, and no one stole one from him. The defendant didn't even put on his shoes to go get help. He didn't respond to the banging doors. He didn't respond to the front door, the back door, the doorbell ringing again and again. He didn't respond to acorns being thrown at the window. Brandon, are you all right? Garcia, are you okay? Brandon, Luis. Again and again and again, and the defendant does nothing. That's not speculation. That's evidence. That's the evidence of his actions. That's evidence of why he never responded to those calls, to the bangs, to the knocks, to the rings, to the acorns. It was because he intended for Luis to get shot with his gun. And he did it knowing the natural consequences of shooting anyone or anything in the back of the head, that Luis would die. That's evidence that this devout man, prayerful man, did nothing to help Luis. His bullets loaded into that gun, loaded into the chamber by pulling the slide inside his house, shooting Luis in the head. And not only is there no physical evidence to suggest that there isn't another person present, but why he didn't answer his phone is simple. He didn't want to get help for Luis. His failure to answer the phone was voluntary. He did what he wanted. He did nothing. Just like he fired because he wanted. He shot because he knew what would happen. For the defense to now come in here and cast aspersions and ask you to speculate that he was so devout, all he could do was drop on his knees when he found Luis. 5 hours. 5+ hours. When police are finally called, when Fran and Danielle discover the horrible truth. And while some mystery killer is out there, had put down the gun and walked away, to believe that is not reasonable. That is desperation for an explanation to a senseless act. Common sense tells you that the devout man who has a stranger enter his home and has murdered a minister who is trying to help him helps Luis. First aid, 911, run for help, stop the bleeding, something, anything. And the defendant did nothing. He did nothing because there was no other person there. There was no mystery man. There was the defendant, his 9mm bullet, his 9mm casing, his 9mm gun with his fingerprints, and no one else's. His bullet doing exactly what he knew it was going to do. Now, the defense wants you to speculate about a couple other things too. Wants you to speculate about the swabs from the gun's grip or on the trigger, that it would have shown that the defendant was not the shooter. That touch DNA could have been left there by the mystery killer after he got the defendant's gun from the defendant's cabinet or from 2 zipped up bags down the hall, which he then would have zipped up on his way back out but left the gun there. Or that the GSR residue would not have been found on the defendant's hands or the clothing. He wants you to speculate that there could have been some information on the defendant's phone that showed that somebody else could have been coming over to the house to meet with the defendant. We heard that in opening. And then it was to meet with Luis. We heard that in closings. And that's the person, or those are the persons, who could have shot Luis. And at last, if the government had just tested those swabs, checked the swabs from the hand, grabbed that phone, those tests would have revealed that the defendant did not do this. All of that is speculation, designed to make you look anywhere else but at this man. The evidence in the real world, even on each of those things, points at this defendant. So let's talk about the gun swabs first. Let's break this down. Investigators knew that the defendant had definitely touched his gun. Fingerprints came back. Fingerprints testing showing the defendant's prints on the gun. And I'm not going to take my time going through it, but you recall some of those images that we looked at with specifically criminal hysteria. Bias on all of those dots, all of those color lines, 3 different levels of confirmation to be able to find out that that is in fact his fingerprint. Bias there. The fingerprint showed the defendant tested the prints, or defendant's prints were on the gun, and not just anywhere on the gun, but at the top of the slide. And here. Right near that clock symbol. Prints left by the skin and the residue and the oils that are on everybody's hands. Hands which are made of what? Blood, bone, and skin. Hence, hands filled with DNA. The defendant kept this case in his lock cabinet in his bedside table in his bedroom next to his bed. And we know from Mark Castiglione that a few days or a week before he went shooting with Luis at a gun range. And then, of course, the gun is found by the police in the defendant's house on top of those white cabinets that are there at the end of the hall, feet away from the bullet casing that we know the gun fired. Outside the bedroom, laying on that shelving unit. Now think about it. We know Officer Verrier touched the gun to make it safe initially. We know that. And even in that brief interaction, Officer Verrier's fingerprints were never identified on this gun. The theory that DNA testing on the pistol grip is going to change everything does not ring true, because it's a flawed theory. Because there's no evidence presented that suggests that a stranger was in the house and did this. A house that's filled with, that the gun sits in, the defendant's own DNA. So to think that DNA swabs would show that a mystery killer instead of the defendant's own DNA, it's not reasonable. The GSR swabs. Let's talk about those two for a minute. To think that the results of the GSR swabs would upend everything is also similarly unreasonable. Because the defendant's theory is that the police should have tested it, and if they did, they would have seen that there was no GSR on the defendant's hands or on his clothing, and he could not have been the one to fire the gun. That's what we heard as an argument a moment ago. What do we hear for testimony, though? What was the evidence? That when GSR comes out from behind the bullet, it opens up in a cloud. And as you heard from criminal hysteria, can expand out to approximately up to 6 feet. This is a small bedroom. The defendant is found laying on the floor of the room. Luis was shot. Collapsed. Roughly here, below that little white circle around the bottom. You heard that testimony from Francis Pastana. You heard that testimony from Danielle Potovano. You heard that testimony from the 2 Londonderry officers who went in initially. So he's laying on the floor with the casing that held the gunpowder right next to him. Luis's body, 3 feet away. The bullet coming to arrest, 2 feet away. The barrel of the gun that fired that bullet, 6.5 feet away. When Danielle saw him on the ground, he would have been laying in that GSR right there on the ground. To speculate that testing from the swabs, both from his hands and clothing, 12 hours later at the police department, would have shown that he had no GSR on him after he was found lying down in the spot where the gunshot was fired, that defies real-world logic of where GSR fell. To think that the results of that test would somehow show that he conclusively was not the shooter, that's not reasonable. Finally, let's talk about the defendant's phone. In what must be the first time that somebody said, "You should have seized my phone from me." And my phone that I own, that would have shown that somebody else did this. You heard from Sergeant McCauley and Lieutenant O'Leary that in this state, police cannot just seize whatever they want, whenever they want. They need probable cause to apply for a search warrant, right, that they have to have probable cause that evidence would be seized in or on the item that's taken. It's written that way in our Constitution. They have to follow the authorization that they were given when they were executing the search warrants they had. And you saw evidence of that. When we looked at the details of Luis Garcia's phone, it was only because Patricia Garcia had given permission for that to be analyzed, a consent to that search. There's no evidence that somebody else was involved in the crime. So there's no evidence for police to be able to seize or search the defendant's phone. And these arguments just a moment ago, the defendant, where he was that day. What, he left the house in his socks that day? He just went where? Nowhere. That there was somebody else who went in and could have gotten that gun not out of the locked cabinet, but out of the bag in the hallway. The bag that was sealed up when police got there. So the defendant came in, I'm sorry, not the defendant, the mystery man comes in, opens his bag, opens the second bag within the bag, and could have taken the gun out of this bag, even though that was not the testimony about where Brandon kept that gun. And the casings, well, should have looked at these casings too. They could have been consistent. JGO2 specifically states Exhibit 112. The 9mm bullet, the casing that fired the bullet that killed Luis Garcia. And the defendant's exhibit of the casings in the bag. Notice everything different about the end? It's not even the same height of casing. Your eyes can show you that. One that has the additional space around the outside. One that doesn't have a primer ending that looks like this. These aren't even the same type of casing. You don't need to be an expert to see that. So, we've discussed the defendant's theories. We discussed what the defendant did to Luis when he shot and he killed him. Now, let's look at what all of that means under the law. Judge Ruoff will explain the law to you, what it means to commit second-degree murder, both knowingly and recklessly. And lesser included crimes, if you consider those two, decide that he is not guilty and then move on. In deliberations, you should consider the following, though, when you're discussing the charge of second-degree murder. You've got to decide whether the defendant caused Luis's death, in that the defendant who pulled the trigger on that gun, and we know the person who pulled the trigger on that gun is the one responsible for Luis's death. That gun that belonged to the defendant, his ammunition, his locked bedside table, his fingerprints. And for the variation of second-degree murder with a knowing intent, you also have to consider whether the defendant acted with a knowing intent to cause Luis's death, in that he fired aware that his conduct would cause Luis's death. That intent. When you've heard how Luis was shot, back of the head, through the center, the end of the barrel mere inches away from his head. And he fell and dropped on the spot. And when you heard about how the defendant was found, on the ground, mumbling by his sister and his poor grandmother, having to find the key to get inside the locked house, you should consider all of that when deciding whether the defendant knew that he would cause Luis's death by shooting him that day. Similarly, you should consider, when you consider whether he pulled the trigger, that he acted with extreme indifference to the value of human life. He had gone shooting with Mark before. He had been with Luis before. You heard in just a couple of weeks or days before the crime. He clearly knew how to use the gun. He'd owned it for a while. He knew its deadly potential. So he knew that when he aimed and pulled the trigger at Luis, what was going to happen. And when you consider intent, remember what we learned about the gun itself. This gun is not susceptible to jar off, so this is not an accident. The gun slide pulls to load a bullet into the chamber. Slide that we have, of course, with the defendant's left thumbprint right on it. Defense a few minutes ago talked about what that Brandon had 15 rounds, one here, 14 in the magazine, one there, that's 15, that's all the magazine holds, 15. Gun can't hold more than 15, that's at 15. You heard Sergeant McCauley testify, didn't you? Sergeant, how do you carry it? My magazine holds 10. How do you carry it? I carry it with 11. How? He tops off. He puts one in, loads it in the chamber, and then puts another one in the magazine and reloads it. That's how Sergeant McCauley carries his gun. That's how a police officer has testified how he carries a firearm. That 14 left in the magazine, one in the chamber, and the plus one, that's the one in the back of Lewis's head. That went through the back of Lewis's head. And the trigger itself, how you know it's not an accident. When you think about whether he had the intent to kill, it's a two-part trigger mechanism. It's not an accident to fire this gun. You'll be able to examine this in there. You have to want it. You have to get your finger all the way in there to pull it. This is not just a whoops. This is not just a slip. This is not just, I want to show you something that we went shooting together a couple weeks ago or a couple days ago, and you've seen me do this plenty of times. This is no mistake. When you consider intent, and remember also what we learned about where Luis was shot, back of the head, through the neck, that morning he didn't see this coming. He couldn't use his hands to defend himself. He was facing a wall with his back to the killer. When you consider intent, remember what we learned about what the defendant did, again, after Luis was shot. Nothing. His actions afterwards also reflect his intent, that he knew what would happen and that he caused Luis's death. He didn't call. And lastly, remember what we know about this defendant when you think about intent. A man who knew firearms and knew how to keep them safe. His familiarity with that weapon was unquestioned. He even held on to the booklet. There's no simple recklessness here. There's no negligence here with the firearm. He knew what his bullet could do, and he knew what his bullet would do. And when you consider the intent, remember one more thing. The bullet. This bullet, Exhibit 73A. The bullet that went through Luis's body and struck this wall and collapsed down onto the ground, which caused Luis to collapse down onto the ground. When you have to consider what the defendant's intent was, I want you to consider this bullet. A hollow point bullet, which you heard from Gilterio, is designed to open up on impact, and they have little petals that look like almost like a flower. This bullet that made Luis instantly drop. His spinal cord sending signals to that spot in his neck, pulpified, obliterated, gone. He cannot breathe. And he bled for as long as his heart could keep going before the oxygen deprivation stopped it altogether. You heard from Dr. Duvall. He may have been unconscious. One would hope that he was. Because the alternative is horrific. That this man, who had asthma so bad that he couldn't work in a packaging plant anymore, had to leave that refrigerated environment, may have died conscious, aware, and unable to breathe. And the defendant did nothing to help him. The blood stayed where it fell. Exhibit 109. It's not tracked all over the floor. It's not all over the defendant. You won't see any of Luis's blood on him in his booking photos, not on his jeans, not on his arms or his shirt, and not on his clean white socks. And he was so wrapped up in prayer for Luis that he didn't hear anyone call, pound on the doors, ring the bell, throw acorn or anything. He didn't take one step near Luis. Think about that when you look at that bullet and when you decide whether or not this defendant had the intent to shoot Luis in the head and knew that it was going to result in his death. Also, we told you at the beginning that you bring your common sense here with you into the courthouse. You don't lose that. You don't abandon that. Jill Terriell testified that an all-copper bullet was unusual. In her nearly, 20 years of firearm examination, she was unfamiliar with it. And she had to look it up. The casing and the bullet, after it had been delivered to her, she had to look that up. Fiocchi, all copper, 90 millimeter, from the defendant's box, typically a very light 92 grain bullet, give or take a few tenths of the gram is what we heard, from the manufacturer. A unique round that the criminalist, who had, again, almost 20 years experience, after working at places like Miami, New Haven, Connecticut, had to go ahead and look this up. And the spent bullet weighed what? 84 grams. 84 grams. It appeared to be missing 2 petals. 2 petals of this hollow point jacket that pushed open when it hit, mushrooming open, causing even more damage inside. And the 2 petals left behind by this bullet's jacket when it went through its target. You see those 2 petals are. Right in Luis's neck. The whole back and forth over whether this bullet could have been fired by some other 6-line polygonal right-hand twist. The bullet that killed Luis was fired by the defendant's gun. That's a fact. So even if he wants to say it's from some other person or some other gun, the casing is from his gun. The bullet is from that box of ammunition. There's no other bullet in the room. Not in Luis, not anywhere. None. Just the one. Think about that when you think about intent. That bullet from that case that follows evidence. Evidence that this man knew what was going to happen when he put that gun and aimed it at the back of Luis's head. He fired his bullet and he hit his intended target. All the speculation on coulds, mays, you've now seen that it is just that, pure speculation. It's not reasonable. It's not based upon the evidence. If we're going to quote Ben Franklin, let's do it right. Facts are stubborn things. And the facts have been shown in this case. That this man here these hands that never got a chance to paint that day, hands that never got a chance to defend himself, hands that never got a chance to pray with someone one last time, the hands that worked, that cooked, that prayed, that loved, that counseled, that gave service to others, that tried to counsel, tried to help this defendant. And then this man, took out that gun with his ammunition, pulled back that slide, aimed it back of Luis's head, and pulled the trigger. Because there were only 2 men inside that locked house, and only one man knew what was coming. This is not jumping to conclusions. It's called following the evidence to where it leads. And all of the evidence leads to one clear and logical conclusion beyond all reasonable doubt. The defendant's bullet, the defendant's casing, the defendant's gun with the defendant's fingerprints firing a bullet into the back of Luis's head inside the defendant's house. What the defendant did was murder. Plain and simple. He committed a murder. He got his gun from the locked cabinet, loaded it with his hands, aimed it at the back of Luis's head from as few as a couple inches to as much as 12 inches away, and he executed him. He executed Luis. No one is jumping to any conclusions. The evidence, physical and testimonial, from his family, from his neighbor, from lay persons, experts, all demonstrated a clear path to the only logical conclusion beyond all reasonable doubt, that the defendant murdered Luis Garcia. That makes him a killer. The defendant may have been found with his hands together, praying, when his mother and his grandmother were finally able to get into that house hours later, when everything went radio silent. Hours after, and even while those phone calls from Pat G were still coming in and nobody was picking up. But his hands, those murderous hands, now we know, God knows, he was not praying for Luis. Return the only verdict that is consistent with justice in this case. Find that man guilty of second-degree murder. Thank you very much for your time.
Thank you, counsel.